Aloha and welcome to Condo Insider, another edition. As we've said many times before, about 1/3 of our population lives in an association, and this is Hawaii's show about association living. I've been involved in the legislature for more than a decade, and every year I find bills are introduced that affect association living. And by my count, approximately 80 bills were introduced in the 2016 legislative session that somehow would affect associations, the boards and owners' rights. And every year we go through a consistent lobbying and discussion process to try to get all good bills passed. Today we're very lucky to have one of our industry titans, as I would say, Jane Sugimura, who's a local lawyer, president of the Hawaii Council of Community Association, and has been involved in association matters for longer than I have been. So I want to welcome Jane to the show, and I'd like to just have you tell us a little bit more about your background in HCCA.
Okay, well, first of all, as you mentioned, I'm an attorney. I've been licensed to practice since 1978, and I do basic business law. I represent landlords and landlord-tenant litigation, and I'm also a board member. That's how I got involved with these condos. I'm also a board member for a townhouse community in Aiea, and I've been a member for almost 30 years. That's really, it doesn't seem that long, but I've been a member for almost 30 years. And I also sit on a board, a high-rise condominium board, and I've been there for about 23 years. And so, you know, there are differences, but, you know, I think overall the issues are the same, and that's how I got involved. I mean, I was, many years ago, a good friend of mine who's an attorney, Milton Motooka, who was very active in the Hawaii Council, and you know, he was very instrumental in setting up CAI. And he recruited me to be on the Hawaii Council, mainly because I found out later, because I lived in the Pearl City area. And the representative who was chair of the Housing Committee was the representative from Pearl City. And she made a comment that she didn't have a leasehold problem in her district. And at that time, all of the condominiums were Kamehameha schools, Bishop Estate owned. And so that's how I got involved with the Hawaii Council. And Hawaii Council has always, it's an organization made up of board members and professionals in the property management industry, property managers and some contractors and vendors. And we're involved, I mean, we deal with issues that relate to condominiums and associations. And at that time, my issue was leasehold. And over the years, we were able to address that issue so that at this point, it's not such a big deal. We had Chapter 38 that we managed to get passed in the city, which resulted in a lot of fee conversions. In fact, the Hawaii Association of Realtors told me on the eve of the repeal of the act that I shouldn't feel bad because the law ended up converting over 30,000 units from leasehold to fee. So, but it's still a tragedy that there are still leasehold units out there, and there is no remedy for those unit owners. But other than that, we are involved in condominium governance issues, and we're at the legislature every session. We're at the city council. Right now, we've got an issue with rubbish removal.
Yeah, tell me about that. I know that there is an issue in rubbish removal that the city picks up some of the condo associations and nonprofits.
Right.
And so all of a sudden, they decided they weren't going to do that anymore, and then the union filed a lawsuit against them. What is the status of that today?
Okay, the status of that is the union filed for an injunction, which they won at the state court level. And the injunction basically said that the city could not stop the service. And so the city had to continue to do the rubbish removal. And 2 weeks ago, the Hawaii Supreme Court ruled in favor of the union. The city had appealed the state court judge's opinion, and it went up to the Supreme Court. So now the highest court in the state has determined that the service must be continued for technical legal reasons that don't affect us, but what we're concerned about is that for the last 3 years, the budget has had no money to repair and maintain the front-loading trucks.
Now-
And so last year, we submitted testimony asking for money to be put into the budget, and that was rejected. Now there is a budget amendment that was introduced right after the Supreme Court decision by Council Member Brandon Elefante. And that amendment would allow for about $1 million to be put into the budget to repair and maintain the front-loading trucks. Because right now, if those trucks break down, there's no money to repair them, there's no money to replace them.
Well, some of the city council members argue it's not fair that some condos get free refuse service and others don't get free refuse service. How do you answer that?
Okay, I answer that you know, there was a process this has always been an issue with condo owners. We pay real property taxes, but we don't get services. And many, many years ago, back when Arnold Morgado, I think that was in the 70s, early 80s, Arnold Morgado was city council chair. We were able to negotiate a process with the council whereby condo associations could contact what was then with this, you know, predecessor to environmental services, and an inspector would come out, take a look at the space to see if the truck could turn around, and the association had to buy the smaller dumpsters that would fit into the front-loading trucks. The small condos and the townhouse projects were able to take advantage of that service because the city will only do 2 pickups a week. The high-rises, even though some of them you know, applied and were granted the service, they have to have pickup 6 days a week for health and safety reasons. I mean, you have 600 units, like, you know, like the Marco Polo or Discovery Bay. You can't have twice a week pickup. You're going to have a health problem. You're going to have rats and roaches. So you got to have all that stuff taken away. And the city would only come twice a week. And their private haulers would not allow these high rises because we had 3, and one of them was in Waikiki, who did qualify for the service. And so it was a choice by the condominium not to take the city services because they couldn't get their private hauler to do a partial service. So yes, and people say, well, it's not fair. But the problem is that, you know, practically speaking, there's no way for the city to provide the service twice a week and for the high rises to still safely, you know, allow for removal of the rubbish.
Yeah, so I'm hearing it's a matter of fairness. We pay property taxes, so we're entitled to services.
Yes.
The city has a set of specifications that they give twice a week service. You have to have a certain size dumpster. The facility itself.
You have to have room for a turnaround.
You have to have room for a turnaround. And so back when this was discussed with the city council decades ago, that was the compromise was made.
Yes.
And now they're trying to take that away from us.
Yes. And at the time, I mean, I thought that there was you know, something in writing. I'm told there was nothing, because we talked to environmental services and they don't have anything in their records to show that. But I remember a process. I remember telling people, we put stuff in our newsletter. I remember talking to Arnold Morgado, and it went on for years. In fact, one building behind us, Pacific Village Annex, their board president was our treasurer way back then, and she applied, and she got it for her condo. You know, so I was aware of the process, and so I was really surprised when I heard that the service was being discontinued because the certain council members didn't feel it was fair that some condos were getting the service and others were not.
But the truth was they negotiated that long ago, and the
Yes.
condos that can meet their criteria should get it, because being in the property management business previously and knowing the costs of private refuse hauling, if you did away with that, that could cause an association to have to raise their maintenance fees $25 to $50 a month per owner on an average, just to replicate the service they're now getting for free and paying taxes on for free.
Right, but you know, they had to pay to buy these dumpsters, which aren't
Right.
cheap.
That's right.
And they are specialized dumpsters because they fit on. They have these front-loading trucks that come in and lift them up and, you know, remove them. And so so that was one of the conditions of getting the city pickup, is you have to pay for those new dumpsters.
And when does this amended bill on the budget get heard?
It gets heard on June 1, and we have the information on the bill number is Bill 15, and in parentheses, 2016, which is the year, CD2. It's going to be heard on June 1st at City Council on the second floor in the committee room, and on our website, and our website is Hawaii Council, COUNCIL.com, and we have instructions and we have links to the city, so even if people can't come because it's going to be a long day, you know, when you go for these budget hearings, you kind of go in the morning and you sit all day for your turn to talk. But if you know, we encourage people to send in written testimony to say that they support the funding for these front-end loader trucks, and we're putting information on our website for people to submit testimony.
Do you have any prediction what's going to happen?
I'm not really sure. The council is kind of unpredictable. I know they claim that there is a budget issue, and $1 million is a lot of money. So if we can get some money to at least prepare, you know, for repairs of the truck, I think that I would consider that a victory. But right now there's a budget amendment for, I think it's $1.1 million, and that would pay for 3 trucks, replacement costs for 3 trucks.
Well, it seems to me if the Supreme Court has ruled saying they have to provide the service, it'd be irresponsible if they didn't budget for it because they know they have that cost. You know?
Right.
And
or they can say, well, we'll give you some money now and we'll do some later. I would be happy with that. And at least there's some money in the budget to take care of repairs, and it's a recognition that the city will continue the service. They can't appeal anymore because, you know, this is a ruling from the Hawaii Supreme Court. So this is the end of the road for appeals. So they have to continue with the service, which is a victory. It is a victory for those people, those condo owners, and a lot of them lived in Mililani, and we had a smattering who lived in Kanaue and Kailua and in the Ewa district, Ewa area. And you know, I think it's a victory for them because I know they were on the phone, they were calling their council members, they were submitting testimony, and so, you know, I applaud them for their vigilance.
yeah, the thing that bothers me, if that's the right word to use, is that we as condo owners pay taxes just like single-family homeowners.
Yes.
Single-family homeowners get refuse service. And yes, condos have some unique facilities issues and turnaround issues and the type of trash receptacle use issues.
Mm-hmm.
And we agree with the council previously, if they met this criteria, they'd provide the service and
Right.
treat us equally. And now they're trying to take that away from us, primarily for budget reasons.
Right. And we've been fighting with them for a really, really long time. So, you know, we were very concerned when the city made the announcement that they were going to cut off these services. And the minute I heard about it, I picked up the phone and called people that I knew on the city council saying, you can't do this. And then they told me that they heard that this was, you know, the reason why the condos had the service to begin with is because they knew someone. I said, no, there was a process. There was a process. All the condos who had service went through the process. And, you know, so maybe it wasn't in writing. I thought there was a written procedure, but we were very much aware of the process. And so we didn't think it was fair for them to cut it off. And so we're very happy with the Supreme Court opinion.
Well, we're going to take a short break right now, but we're with Jane Sugimura talking about issues before associations. And when we come back, we're going to talk about the state legislature.
Hi, I'm Chris Leatham here with Think Tech Hawaii, and I invite you to watch my show, The Economy and You, each Wednesday at 3 o'clock here in Hawaii on OC 16. We look forward to seeing you. Aloha.
Hello, I'm Crystal from Quack Talk. I've got a new show here. You've got to tune in. Check out my topics on sensitive, provocative female issues. So Tuesday mornings, 10 o'clock. Don't miss it. It's going to be fun and dangerous.
Aloha. Ehana Kako is here every week on the Think Tech Hawaii Broadcast Network because we need to take a dispassionate look at the issues. Here in Hawaii, we need to understand what's going on in the economy, in the public sector and the private sector, what's going on in terms of schools and with the people whom we love and see every day. I'm Kili'i Akina, president of the Grassroots Institute, proud to be part of Think Tech Hawaii, and we'll see you here every Monday at 2 o'clock p.m. Aloha.
Welcome back to Condo Insider. We're talking with Jane Sugimura about issues involving the laws between our city council and the ordinances and our state legislature. And when we signed off for a second for a break, we were talking about the city council and the recent Supreme Court decision mandating that those condos that previously had refuse service needs to continue to have that service. And that was a Supreme Court ruling. And although the issues in that particular case had to do with the union and privatization, the fact is that the impact is still in the condos that could have to pay $25 to $50 per unit more in maintenance fees if they lost this service. I'd like to go on to the state legislature now and say, you know, the fundamental principle of condos is self-governance. I think that's been, and it's an issue that no one seems to really understand. How would you define self-governance for condos?
Okay, self-governance to me is like, you know, is like a government. You have people who vote for elected officials, and they trust those elected officials to make laws and to have them enforced. And that's what I you know, that's what self-governance means, and I think it's basically an empowerment of the unit owners of a particular condominium, and allows them to vote for their directors and have those directors hire people to manage the building and take care of it, and if the board somehow does not do it, it's up to the owners to monitor by going to the meetings, by talking to their board members and talking to other owners and giving feedback to the board, because the board doesn't act in a vacuum. They need to have input from the unit owners, even if they live in the building, because, you know, a lot of us who live in condominiums, we're gone all day because we're at our jobs, or, you know, we're just out of the building, so we're not there all day. Even retirees, you know, they have, you know, nonprofits that they do, they have, you know, sports things that they do, and so they're not in the building either. So it's important for, you know, owners and the board to talk together. And this session, I think, there were, like you said, there were almost 80 bills introduced, and none of them made it. There's not one condominium bill that made it out of the session, out of those 80s. And I think that is a reflection on the fact that the state of Hawaii legislature supports the idea of self-governance, because the bills that were introduced, for example, there was an ombudsman bill that would have made, you know, somebody, a condo czar, who would be the one to decide disputes between, you know, condo owners and their boards, and you know, these are things that, you know, I have a concern that if you allow this to happen, you take away power from the unit owners and from the board to make their own decisions, their own destiny.
And from my experience, what I find frustrating is when you look at the issue of self-governance, we see every legislature, all these bills come in, where in fact, if an owner, for example, or an association, for example, believe that they wanted term limits for their board members, they as an organization can propose it to their organization, and that organization can either vote it up or vote it down, and that's self-governance, that those unit owners in that condominium are determining how they want that association to be operated. But what happens is, those owners don't seem to get the support of their own condominium, so they come into the legislature with a one-size-fits-all concept and tries to get the legislature to force it down everybody's, I hate to use the word throats, but force that on each association whether they want it or not.
But that assumes that all associations are the same, and they're not. They're not. I mean, you have associations that are residential, you have senior housing, you have agriculture, you have commercial, and so it's not one size fits all. And that's the I think the concern I have with people coming into the legislature trying to change 514A or B to affect one issue. And the way I see it, condominium owners in a particular condominium project have the right under their documents to vote for their directors. If they're not happy with the directors, there's a process that is in the statute, in their declarations, how to remove, how to change those people. But they have to, owners have to stay vigilant, they have to stay involved in the project. They can't just say, oh, well, I'm not on the board, I don't care, and I'm just gonna pay my maintenance fees. If they do that, then what they're doing is turning it over to this board, good or bad, to make the decisions for the entire building. And I know that, some of these bills like the term limits and the ombudsman bill, they come from the frustration from certain unit owners. And those unit owners have problems with their boards. And, what I've been telling boards is and I don't think it's a large, based on what we know, it's not a large number of condominium associations. You're talking maybe a fraction, maybe less than 10% have these problems with their boards and their owners. But the board members, based on the concerns that are expressed to the legislature, they're not listening, or they don't allow the unit owners to speak. You hear about situations where boards don't even allow their owners to talk in the owners forum, or there is a mechanism under 514 A and B where the board can make a motion at the beginning of the meeting to curtail any input from the owners. And some boards do that, and to me that's wrong. If I was a board, I would welcome, and we, both of my boards, we have an owners forum. And you get good information. You can't be everywhere all the time. And so input from the owners, good or bad, is information that the board needs to know in order to make their decision in operating and maintaining the project.
Well, I agree with you. That's very, very important. The boards be transparent, engage their homeowners, treat them with respect, and give them an opportunity to be heard. And that means that they can be speaking in the owners forum, or they might be making a motion on a particular issue before the association. They should be given a right to say, I agree, disagree, or I agree with these changes, whatever they want to do, and that's the proper way to do it. I think that statute was written with regard to the board's ability to stop owner participation, because rarely, but on occasion, some owners try to monopolize the meeting and keep the board from getting their business done, and it continues to go on and on and on, and they can't do it. So I think the statute was written for that exception, not for an ordinary rule to keep people from participating.
Except that under, both 514A and 514B, Robert's rules is what is used to, regulate these meetings. And Robert's rules they have procedures.
Right.
Where the chair, the person who's chairing the meeting, can call somebody out of order to terminate that person from speaking. And if it gets to the point where the person doesn't listen to the chair, you can have that person removed. You can call the police and have them removed, which is, really extreme. But I think usually when you're the chair of the meeting and you operate under Roberts and say, I've given you 5 minutes, and, we have other things on the agenda, and, we really need to move on. And so, you can put your comments in writing and I'll circulate it to the board. You can do things like that to stop that person from talking so that you can go on with your meeting. But the chair of the meeting under Robert's rules is the person who's supposed to keep the meeting in order and keep it running smoothly. So if the person talks, or the board can set time limits at the beginning of the meeting, that's fair. In other words, anybody who speaks can only speak for 3 minutes. And that means everybody is subject to the 3-minute rule. And that's fine. That way everybody gets a chance to speak, and you can't speak until everybody else has spoken. And then you can get another 3 minutes. But at some point, the board has got to finish conduct its business, and it's up to the chair. And under Robert's rules, the chair does have the discretion to say, we need to move on.
And I think part of that is that, again, back to the statute side of it, is I've been to meetings where, like a 16-unit project that we've had, 5 lawyers present and 2 police officers. and even though we say that we'll have the rules, you have some people who don't want to follow any of the rules. Right. So the statute does provide some additional leverage to do that. But going back to the legislature, I know we had all those bills that came in. My understanding is only one homeowner association bill passed. House Bill 1541.
Right.
And then there was a resolution about helping homeowner associations to have dispute resolution.
Right.
Let's briefly talk about each one of those. Let's start with HB 1541. What was that all about?
Okay, what it is that, you know, homeowners associations is governed by Hawaii Revised Statute 421J. And condominiums are governed by Chapter 514A and 514B. And both of those statutes are quite substantive. I mean, they're maybe 20 pages, whereas I think 421J is maybe 4 or 5. And so they're, you know, even though the issues facing the community associations as far as procedure and process are similar, like they have board meetings and you have election of officers and you have proxies. This bill focused on the proxies that were used in the elections of, in the community association elections. And basically what happened is they changed the language so that the proxy for a community association would look like the proxy in a condominium. In other words, the check boxes would be the same as you do have for a condominium. In other words, if you could submit a proxy, and it could be for quorum purposes only, or it could be for the board to vote as a whole, or a vote to divide equally among themselves. And it also added a provision which wasn't there, that managing agents and resident managers or their employees could not solicit proxies for that particular association. It's in the condo statute. It wasn't in the community association statute, so it was basically a housekeeping to make it similar.
I think the other thing was that under the condo statute, we changed a while ago, that it used to say that if you wanted to solicit proxies, you were limited to 100 words. And I can remember as a management company, we would get these arguments from whether the middle initial counted as a word, did the date count as a word, is a telephone number 1 word or 2 words, because there's this political battle began. That's 101 words, you can't mail it out. And so we changed the condo statute some time ago to say, you get 1 8.5 by 11 one-sided sheet of paper.
Right.
And I think this House Bill 1541 did the same thing
Yes,
for the
it did
for the
that.
homeowner associations. And so then we're off the hook about, is that a middle initial or telephone number, 1 word or 2 words, is the zip code count? Because so many people take this very emotional,
Yes.
and they don't want the word to get out, where I'm back to transparency and let the debate be held, and let the people vote as they choose under self-governance, and that's
Right.
kind of where I'm at. And so I didn't see that on the governor's veto list, potential
No.
veto list, so the probability is homeowner associations will have the same proxy solicitation rights as condos.
Right.
And the managing agents and our resident managers, site managers, are not allowed to solicit proxies, which is only fair.
Yeah.
And the resolution had to do with trying to find dispute mechanisms for
Right,
these
and
associations.
what happened was, I think, the community associations, they've gotten to a point where they are starting to have disputes, and they want to find a cheap, quick way to resolve them. And they looked over at the condo situation and figured, oh, the condos have mediation that is paid for, so that is subsidized by a fund that is in the real estate commission. And when they tried to take advantage of that program, they were told, oh no, this is only for condos, because the condos have been assessed, and they have been assessed. The condos have been assessed for over 20 years, and it started off $1.25 per unit, and now I think it's up to $3, $3.50 every 2 years. Every unit is assessed. So every other year, the association will write a check to the state of Hawaii, and it's, if you've got 100 units and it's $3.50, it's what, $350 you would pay.
Yeah, so the short answer is the condo side are paying for this dispute resolution because every other year they're assessed per unit, where the homeowner associations are not paying anything into it.
Right.
So it would be unfair for them to be able to use the fund, which is about 1.8 million last time I looked at the real estate education report.
Right.
It'd be unfair for them to be able to use the condo owners' money for their dispute resolution.
Right.
So this resolution was for the government to look at how can we help resolve that problem by
Right.
giving
And
homeowner associations.
This is to set up a task force to look for a funding mechanism, to set up a program similar to the one that now exists in the DCCA, Real Estate Commission, where there is a condo ed fund, and part of that is used to support dispute resolution, which means mediation.
Well, again, we're going to take a short break and continue our conversation about this year's legislature. And we've been talking about bills that have passed, and only 2 of them, and 1 bill and 1 resolution. And when we come back, we're going to talk about those that failed and what we can expect in the future.
Hello and welcome to Think Tech Hawaii. I am Ina Chang. I am the guest host for Small Business Hawaii with Reg Baker. Tune in every Thursday at 2 p.m. and watch us. Aloha.
I'm Jay Fidel, CEO of Think Tech Hawaii. We work for the common good. We want to bring people together. We want to create a platform for civic engagement and raise public awareness. You can find us at thinktechhawaii.com. Thanks.
Aloha, my name is Justine Espiritu, and I am the co-host of Hawaii Farmers Series. This is my co-host, Matthew Johnson, and we are live with you every Thursday at 4 p.m. at thinktechhawaii.com. And our show focuses on Hawaii's local food community. We feature not only the farmers that are producing our food, but we also feature the supporters and other folks involved in the community that are trying to promote local agriculture.
Well, we're back to Condo Insiders, solving all the association's problems in the world and talking about the legislature and city council. And as Jane was saying a few moments ago, only 1 bill was adopted this year, and that's House Bill 1541, that gives homeowner associations the same proxy solicitation rights as a condo for the most part, and a House resolution to try to find a dispute mechanism for homeowner association disputes, because as we heard, condo associations pay into a special fund, therefore the financial resources are available, where homeowner associations don't have that ability. So a resolution to look at what mechanisms can be put in place to help homeowners resolve disputes was a resolution for that to be looked into a task force. But we also saw that, and we talked about the 1 bill that was adopted. That means 79 bills were not adopted. And there was some pretty ugly stuff out there from my perspective. And I'm going to talk about these. We only have a short 15 minutes left in our show, so we're going to kind of go through a couple of them pretty quickly. And the first one is going to be what we call the Condos are. And that
Yes.
was an ombudsman.
That was it.
And to me, I thought it kind of bizarre just to use the word czar in this discussion, condo czar, because if you go back in history, czar was a pretty much monopolistic king, for lack of a better word, and great unlimited authority. And I'm not sure that's what an ombudsman's role is.
Right. And, and it seemed like the ombudsman would have a lot of power. And the way the bill was set up, it would have been in the Attorney General's office, and it would have been funded by the Condo Ed Fund. And that's the fund that all of us condo unit owners subsidize. This is the one we pay into. So I guess one of the concerns I would have is, that fund was intended for condo education, and then some of it got allocated to dispute resolution, and now it's being allocated to the condo czar and paying for the bureaucracy that would ultimately follow. And and I know when that condo ed fund was first set up, we complained bitterly because we said this is an additional tax. Condo owners are being forced to pay additional money to the state of Hawaii for what? And now it's up to $350, and now there's a condo czar who's going to need a whole lot of money, and we think that this is way beyond the concept of the people who set up the condo fund 20 years ago.
But an ombudsman is somewhat like a mediator. They have the ability to look at issues and try to bring resolution. But an association and an owner, it's a contractual relationship. I'm not sure an ombudsman under any authority could change a contractual relationship that exists today that owners signed on to when they bought their unit, and boards have a fiduciary obligation to comply. I don't think any law could just arbitrarily take away that contractual relationship. Am I wrong, or?
No, I agree with that. And, the fact that this bill even came forward, to me, is a threat to self-governance. Because, I mean, what the ombudsman is doing is basically making a decision on an issue between maybe a board and a unit owner. And that's something that should be decided amongst those two parties, or if it has to go to court, by some third party, not by, like a judge or an arbitrator. And hopefully it doesn't get there, because that results in expense to both parties. But it just seems unfair to give that much authority to one person who has no affiliation with the board or the unit owner to make those decisions.
It goes back to something I said earlier, that I feel sometimes these bills come forward because owners don't like the business judgment the board make. It's not that they violate any of their governing documents. They just don't like the decision the board make. And they're searching for some third party they can go to try to force the board to change their mind or make another decision, or maybe overrule the board. I'm not sure how you would do that.
Well, yeah, I think that that's true, and that's why I say the ombudsman bill, to me, is an encroachment on self-governance. Because, why have, if you're going to have somebody making these decisions, then what does that say about self-governance? That means that you're not doing self-governance at all. Because here, if there's a dispute, you're going to go to the ombudsman who's going to make the decision. And I think that takes away, it doesn't allow the parties to resolve their problems. And the fact that some third party who may have no idea about the factual situation that is underlying the dispute is going to make this decision, I think it just takes away from the rights of the owners and the board.
I know the industry lobbied very hard, and I think it was 2015 when Act 187 was adopted. And basically what Act 187 did was bring forward a dispute mechanism between a board and an owner, where it's called evaluative mediation. And you get someone like a retired judge to a professional dispute resolution organization to hear both sides, but now you have an experienced retired judge who not only can say, let's try to get a meeting of the minds, he can say, I think you're wrong, and if I was a judge, I'd make you pay all the legal fees, and be much more forceful in trying to bring a resolution. So my kind of view is that we just adopted that rule in 2015, that law in 2015. The rules from the Real Estate Commission just came out. We should give that a chance to work before we go down and try this ombudsman program.
Yes, I agree with that. In fact, our group did advocate. We testified in favor of that bill, and we testified also in front of the Real Estate Commission for implementation. And we're very much in support of that. And the reason why the evaluative mediation program, became an issue is before that there was something called
Condo court.
No, it was the other type of mediation.
Oh, facilitative.
Facilitative. And the what we were hearing was associations wouldn't show up. They would just ignore it and wouldn't show up. And with facilitative mediation, both sides have to agree. They have to agree before there is an agreement. And so if the board, right or wrong, decided, heck, we don't care, and we're never going to agree with the homeowner, and say, no, 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 you get no agreement. But with facilitative, with facilitative, what you do is you get a professional, and in this case, most of them are attorneys or retired judges.
You mean evaluative? In
Evaluative.
this case, we're talking about evaluative.
Evaluative are attorneys or retired judges. And what they do is they listen to both sides, and they basically say, you've got a good case, you've got a bad case. And because of their background, it carries a lot of weight. And what the mediator then tells the party is, well, if you go forward with this, it's going to cost you a ton of money in legal fees, and you're going to lose. And you're going to have to pay the other side. And, and this is more conducive to a resolution. You know, when they hear it from somebody with, you know, some credibility, and, you know, the person who used to wear a black robe has got a lot of credibility, and because that's, you know, what they do, and so when you have a retired judge telling you you've got a lousy case, or you've got a good case, but there are these issues, you know, and I think it facilitates, it makes the settlement happen.
Well, judges, retired judges certainly are very adept at expressing themselves in clear, uncertain terms.
Yes.
And I think that's what's necessary sometimes, but which was bizarre about that ombudsman bill, because there have been arguments about conflicts of interest. They threw in language that mandatory education for board members had to submit their financial statements to the ombudsman each year. It was really taking away all the self-governance and theoretically putting under an ombudsman who, in my opinion, still, under a contractual relationship, still couldn't force them to do something if they had the authority, the board if they had the authority. So I'm not sure what the benefit was, but as an industry, we're promoting give it a rest, try Act 187 to do the evaluative mediation. The essential way it works is that you go down to one of the 4 approved evaluative mediation firms. They're listed on the Real Estate Commission website. You pay 1 hour of mediation time. It's split between the parties, so about $175 a person. The next $3,500 comes from the continuing real estate education fund. And if the mediator said, I'm making progress, he can go ahead and get another $3,500 to bring it to a resolution. So both sides, for less than $200, can get a judge impartially to listen to this case and try to drive a resolution to it.
Right, and I think that's why we supported this, because we thought that it had, you know, a good chance of resulting in dispute resolution, because the whole purpose of setting up a program is trying to get people into it. And I guess the only issue I have with the evaluative mediation is that it's not mandatory. You know, I think that's what we need to focus on, is making it mandatory so that people have to do this.
Well, the original bill, by the way, had mandatory mediation. It was taken out by the legislature. But I'd like to see it also added that the parties can voluntarily elect to have that same program and cost and have it be binding arbitration. Because if the 2 parties are saying, well, let's get this done, because they both select the judge or the mediator, why not just go ahead and close the door and say, look, we agree, let's both agree to make this a binding arbitration. It's the same money out of pocket out of the fund.
Right.
So why not make it mandatory, and if the parties agree, they can also make a binding arbitration.
I agree. I think that's a really good, you know, suggestion. But, you know, to me, I think it needs to be mandatory so that people, you know, are forced. Like, that was the issue with the facilitative. One side wanted mediation, and the other side to say, no, I don't want to do this. And there was no way to require, you know, get them to go into mediation. And this is one of those situations where, you know, you can lead a horse to water, but you can't make him drink.
Yeah.
And so how do you lead somebody to dispute resolution and make him participate? And so that's why I think, you know, we need to go back to the legislature and get them to make it mandatory.
Well, we're coming to the end of our show, and there's a lot more to discuss. I'll have to get Jane to come back and visit me again. I would tell you that we have the Hawaii Council of Community Associations in August is doing a hot topic seminar dealing with ombudsman reserve issues, manager licensing, a whole bunch of topics. And
the future of self-governance.
And the future of self-governance.
And
Jane
how it's your choice as to whether or not you want to continue to have self-governance, or you want the government to take over your business. Your choice.
Let me thank you for being here today. I always enjoy hanging out with you. Of course, I'm on your board, and thank you for being on Condo Insider. And we're on every Thursday from 3 to 3:45 at thinktechhawaii.com. We thank you for participating, and we look forward to you visiting our show again. Aloha.